Criminal Procedure, Rule 112, Preliminary Investigation. Section 1. Preliminary investigation defined when required. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Except as provided in Section 7 of this rule, a preliminary investigation is required to be conducted before the filing of the complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. Section 2. Officers authorized to conduct preliminary investigation. The following may conduct preliminary investigation. A. Provincial or city prosecutors and their assistant. B. National and regional state prosecutors. C. Other officers as may be authorized by law. Their authority to conduct preliminary investigations shall include all crimes cognizable by the proper court in their respective territorial jurisdiction. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. A. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents, plus 2 copies for the official file. The affidavits shall be subscribed and sworn to before any prosecutor or government official authorized to administer oath, or in their absence or unavailability, before a notary public, each of whom must certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. B. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant, within which he may not have been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and this shall be made available for examination or copying by the respondent at his expense. Objects as evidence need not be furnished a party, but shall be made available for examination, copying, or photographing at the expense of the requesting party. C. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavit and that of his witnesses and other supporting documents relied upon his defense. The counter affidavit shall be subscribed and sworn to and certified as provided in paragraph A of this section, with copies thereof furnished by him to the complainant. The respondent shall not be allowed to file a motion to dismiss in lieu of a counter affidavit. D. If the respondent cannot subpoena, or if subpoena does not submit counter affidavits within 10-day period, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. E. The investigating officer may set a hearing if there are facts and issues to be clarified from a party or witnesses. The parties can be present at the hearing but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be held within 10 days from submission of the counter affidavits and other documents or from the expiration of the period for their submission. It shall be terminated within 5 days. F. Within 10 days after the investigation, the investigating officer shall determine whether or not there is a sufficient ground to hold the respondent for trial. Okay. Section 4. Resolution of investigating officer and its review. If the investigating prosecutor finds cause to hold the respondent for trial, he shall prepare the resolution and information. He shall certify under oath in the information that he or as shown by the record, an authorized officer has personally examined the complainant and witnesses. He shall prepare again. If the investigating prosecutor finds cause to hold the respondent for trial, he shall prepare the resolution and information. He shall certify under oath in the information that he or as shown by the record, an authorized officer has personally examined the complainant and his witnesses, that there is reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed of the complaint and of the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend the dismissal of the complaint. Within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor or to the ombudsman or his deputy in cases of offenses cognizable by the Sandigang Bayan in the exercise of its original jurisdiction. They shall act on the resolution within 10 days from their receipt thereof and shall immediately inform the parties of such action. No complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy. Where the investigating prosecutor recommends the dismissal of the complaint, but his recommendation is disapproved by the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy, on the ground that a probable cause exists, the latter may, by himself, file the information against the respondent or direct another assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. If upon petition by a proper party under such rules as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverses or modifies the resolution of the provincial or city prosecutor or chief state prosecutor, he shall direct the prosecutor concerned either to file the corresponding information without conducting another preliminary investigation, or to dismiss or move for dismissal of the complaint or information with notice to the parties. The same rule shall apply in preliminary investigation conducted by the officers of the Office of the Ombudsman. Section 5. When warrant of arrest may issue. A. By the regional trial court. Within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. If he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused has already been arrested pursuant to a warrant issued by the judge who conducted the preliminary investigation, or when the complaint or information was filed pursuant to Section 6 of this rule. In case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice and the issue must be resolved by the court within 30 days from the filing of the complaint of information. B. By the municipal trial court. When required pursuant to the second paragraph of Section 1 of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court shall be conducted by the prosecutor. The prosecutor, for the issuance of the warrant of arrest by the judge, shall be governed by paragraph A of this section. C. When warrant of arrest not necessary. A warrant of arrest shall not issue if the accused is already under detention pursuant to a warrant issued by the municipal trial court in accordance with paragraph B of this section, or if the complaint or information was filed pursuant to Section 6 of this rule, or is for an offense penalized by fine only. The court shall then proceed in the exercise of its original jurisdiction. Section 6. When accused lawfully arrested without warrant. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with existing rules. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Before the complaint or information is filed, the person arrested may ask for a preliminary investigation in accordance with this rule, but he must sign a waiver of the provisions of Article 125 of the Revised Penal Code, as amended, in the presence of his counsel. Notwithstanding the waiver, he may apply for bail, and the investigation must be terminated within 15 days from its inception. After the filing of the complaint or information in court without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask a preliminary investigation with the same right to adduce evidence in his defense as provided in this rule. Section 7. Records. A. Records supporting the information or complaint. An information or complaint filed in court shall be supported by the affidavits and counter-affidavits of the parties and their witnesses, together with other supporting evidence and the resolution of the case. B. Record of preliminary investigation. The record of the preliminary investigation conducted by the prosecutor or other officers, as may be authorized by law, shall not form part of the record of the case. However, the court on its own initiative or on motion of any party may order the production of the record or any of its part when necessary in the resolution of the case or any incident therein, or when it is introduced as an evidence in the case by the requesting party. Section 8. Cases not requiring a preliminary investigation nor covered by the rules on summary procedure. A. If filed with the prosecutor. If the complaint is filed directly with the prosecutor, involving an offense punishable by imprisonment of not less than 4 years, 2 months, and 1 day, the procedure outlined in Section 3, letter A of this rule shall be observed. The prosecutor shall act on the complaint based on the affidavits and other supporting documents submitted by the complainant within 10 days from its filing. B. If filed with the municipal trial court. If the complaint or information is filed with the municipal trial court or municipal circuit trial court for an offense covered by this section, the procedure in Section 3, letter A of this rule shall be observed. If within 10 days after the filing of the complaint or information, the judge finds no probable cause after personally evaluating the evidence or after personally examining in writing and under oath the complainant and his witnesses in the form of searching questions and answers, he shall dismiss the same. He may, however, require the submission of additional evidence within 10 days from notice to determine further the existence of probable cause. If the judge still finds no probable cause despite the additional evidence, he shall, within 10 days from its submission or expiration of said period, dismiss the case. When he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused had already been arrested and hold him for trial. However, if the judge is satisfied that there is no necessity for placing the accused under custody, he may issue summons instead of a warrant of arrest.